What's up, people? Well, Credence and Bishop threw a curveball on us, so we had a little intermission without Credence and Bishop. So what we're gonna do is we're gonna have a little fun with this clip I got from one of my moderators, Monica, Pac-Man, and this is a awesome clip. He asks some crazy questions, crazy. Let's get going, and then we are going to go right into PolyRouple 2. Let's roll.
Sanctions for failure to attend mediation in order to show cause plaintiff for failure to appear for mediation on February 13th, 2023, and 1/2 day hearing on all outstanding child-related issues pursuant to the Domestic Relations Scheduling Conference Order. Appearing at today's hearing via Zoom is the plaintiff, Seth Tucker, and the defendant, Emmy Ann Floyd, with her attorney, Christopher Campbell, and we will take defendant's motion for sanctions and the order to show cause first. And Mr. Campbell, you may proceed.
Thank you. Your Honor, the motion, the written motion expresses the grounds for what we're seeking. I will note that Mr. Tucker has been blowing off all of the requirements of this case so far. He's been sanctioned previously for failure to file witness and exhibit lists and limited by your recommendation in the court's order in the proofs he can present. He subsequently failed to attend 2 mediations, both the child-related mediation and a property mediation scheduled for Monday, Tuesday, scheduled for Monday. And he simply disregards what is inconvenient for him. And as a result, he ought to be limited and sanctioned. And we were asking for a specific sanction of barring him from testifying or presenting testimony in this matter. There are a few other things the court can do to require people to cooperate and follow the court's directions and basically proceed in due course. And so that's why I filed the motion. I'm kind of annoyed that he's at every step of the proceeding ignored proper procedures and orders of the court.
The mediation on February 13th, that was set for a Monday, and I know that you and your client appeared. I also know that plaintiff failed to appear. I guess my question is, Mr. Campbell, did your client, was she out any money as a result of having to go to that mediation on February 13th, which turned out to be useless?
No direct losses, no.
Okay, all right then. Mr. Tucker, what is your response to those issues today?
I would like to express the exhibit and witness list. The only did not I have witnesses. I know I should have done the exhibit list, and I am very meeting because I didn't have the money for it. I was waiting for my first paycheck, and I tried getting a hold of Mr. Campbell, but I couldn't exactly figure out how. I didn't have his phone number in my phone or anything, but yeah, that's the only reason I wasn't at mediation. Other than that, I've been at every single court hearing, every single court date for this, trying to see my daughter, because Emmy has been denying any chance my parents have tried, any chance I tried before she put a PPO on me to see my child, and she just denies and denies and denies.
Mr. Tucker, do you suffer from any kind of disability?
No, sir, I do not.
Okay, so I understand that mediation money, it's $125 to start with to get into conflict resolution services, and I know that it's not cheap, but at the same time, these are really important matters that need to be addressed. And because you didn't show up to the mediation, they didn't get addressed. And now, unfortunately, the court's got to make the decision and take it out of the hands of the parents, where really these decisions should be made. So, I mean, it's right. Frankly, and Mr. Tucker, I mean, I think I've heard your reasoning. You indicate you didn't have the money, but at the same time, you don't have a disability. I mean, it appears that you are a healthy young person, and I would imagine you have the ability to come up with $120 I find that you are in violation of the court's order to attend mediation and that you are in contempt of court on that basis. You are ordered to pay $125 to conflict resolution services within 30 days. That's essentially their administrative and cancellation fee. And you are going to be sanctioned an additional amount of $100, which will have to be paid to the defendant for her inconvenience in showing up to this mediation, which turned out to be a total waste of time. And defendant will be compensated into that amount through the child support order whenever that gets entered as either a debit or a credit. I don't know who the payer is going to be, so that remains to be seen. So that's my order on those two issues. As far as the request of defendant that plaintiff be prohibited from testifying himself and that he be prohibited from cross-examining the defendant and the defendant's witnesses, this court is going to deny that request. It seems that in this court's opinion, it would be an overly broad and severe sanction in light of the offense that has occurred in this case. This court feels that a more targeted sanction would be appropriate, and that's what has been made today. So those matters are out of the way. We're going to move on to the evidentiary hearing regarding child-related issues. And it seems to the court that the most effective and efficient method of proofs here would be to allow defendant to go first because she is represented by counsel, and counsel will be able to get things started here in a manner that is most efficient. So Mr. Campbell, did you wish to make an opening statement as to the child-related issues today?
Very briefly, Your Honor. Yes. I think the evidence will show that there's an established custodial environment with Ms. Floyd. By the way, just to make things clear, the case is designated Tucker versus Tucker, but Ms. Floyd will testify that she's always used the name Floyd and continues to do so. And that's how I've known her, and that's how I tend to refer to her.
Just for context here, Ms. Floyd is the dad slash not dad, what we call it. That's the one on the phone. Mom is with child. What up, Mikey boy? Credence and Bishop in the house.
Parties separated in July of 2022. And since that time, since July, the child Madison has lived solely with her mother, who's provided all of the child's care and guidance during that time. There is a PPO in effect, which has made it difficult for there to be parenting time arrangements. At any rate, the custody factors will also be the subject of testimony, and they will demonstrate that Ms. Floyd has provided proper care and custody for the child, and further that Mr. Tucker demonstrated a disregard for the child earlier and subjected the child to inappropriate actions, drunk driving, and an inappropriate housing environment. So we think that the custody factors will favor retaining custody in the established custodial environment with Ms. Floyd. We would ask that she be awarded legal and physical custody.
And as far as, a specific order of parenting time, what is Ms. Floyd asking for, with regard to that?
Bear with me for a moment while I remind myself. She wants a limited parenting time provision. No overnights at this point because of the child's age and the conditions in which Mr. Tucker is apparently living. She believes that there can be short periods of parenting time with conditions placed on them regarding use of alcohol, safe and sanitary surroundings, and protection from loud noises that she'll testify about. And I think that's it. Basically, she thinks that it's appropriate to have a period of reintroduction before there's more extensive parenting time. So it ought to begin with short and supervised encounters, and then graduating into more extended ones.
Okay, and then as far as the PPO, does it permit the parties to communicate regarding child-related matters at all?
It permits me from talking to Emmy at all, but it does not permit me from seeing my daughter.
Okay, well, so I guess
I can't speak with Emmy whatsoever, indirect contact or direct contact whatsoever with Emmy.
Okay.
That's what the PPO states to me, is what I was told by the Michigan State Police when I got a call.
That is Dad.
Okay, thank you, Mr. Campbell.
Ms. Floyd.
All right, Mr. Tucker, what do you intend to prove today?
I would like to state on the fact of a safe and clean environment. My parents' homes are very clean and safe. I don't know where Emmy is getting her information that she has put into court on my mom's house being a mess. Also, I would like to state that Emmy has lied to the court, stating that she does not drink, smoke, or use marijuana because she has used all of those three things while she was with me and after our daughter was born. And yes, Mr. Campbell, there was one time I drove Madison and Emmy home from a party. I had drank 2 or 3 beers at most, then slept for 4 hours in my truck, and then woke up and ate food. I made sure I was sober before I drove, and I had somebody have my keys until they knew I was sober, and it was not a party. So I would like to know how I'm bringing my daughter around unsafe environments and driving drunk with her when everything I've done for my daughter is for her safety. Because to be honest, I don't care what happens to me. The only thing I care about is what happens to my little girl.
Okay, thank you, Mr. Tucker. And
Okay.
Mr. Campbell, you may call your first witness.
And I will call Emmy Floyd, please.
All right, Ms. Floyd, I'm going to swear you in. Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can lower your hand. Mr. Campbell, your witness.
Ma'am, please state your full name for the record.
Emmy Ann Floyd,
And how long have you used that name?
my entire life.
Okay, and you want to retain that name, is that correct?
Yes, sir.
Okay. And as a preliminary matter, is it correct that you're pregnant now?
Yes.
And do you know the estimated due date?
May 19th.
And is Mr. Tucker the father of this child?
No.
And the child was in fact conceived after you separated, is that correct?
Yes.
Okay. When did you separate?
July.
Year?
2022, I believe.
That's last, is that right? Where since that?
I'm sorry, I was not able to hear that.
Autumn.
I wonder if Mr. Tucker could mute himself.
So, Mr. Tucker, I think we're getting a lot of wind in the background right now. So could you mute your device while we're taking the testimony of Miss Floyd?
This case is a hot mess. It's still going on, by the way.
Okay.
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 Ma'am, once again, you have a daughter named Madison, is that correct?
Yes, sir.
And what's her age?
Just over a year
And where has she lived since you separated?
with me.
And what's the location?
My mother's house in Elmira, Michigan.
And during that time, since the separation of the parties, who has provided for Madison's needs?
I have.
Food,
I have as well.
shelter,
Me, along with the help of my mother. She took
medical
us.
care?
I have.
Who's been the primary person providing guidance
Thank you, Natalie.
for your daughter?
I have.
Has Mr. Tucker visited your daughter at any time since you separated?
No.
Has he had any opportunities to do that?
Yes.
Before you separated from Mr. Tucker,
Okay, so we hit the 2 o'clock like I promised. I know people are hopping in here because they want to see the toe. So let's get at it. We're going to go to part 2 of the PolyRouple, and let's get it going, people.
Just seemed confused.
So I'm going to give you a little background. So what had happened was there was a clinical psychologist came in. There was a part, kind of like a part 2-ish. It was very clinical, very boring. There wasn't really, it was just about mom coaching the daughter if there was an issue there, and dad thinks that mom was coaching when she saw the psychologist to say the right things. Nothing really crazy. I'll post that once this live is over. So if you want to see that section, I'll actually post the whole case. But for live purposes, we're going to hop to when dad is going to speak now. So we're going to get a little bit from the psychiatrist, and then we are going to go to dad. All right. And dad has all the pictures and the revealing of the toe/fungus. Here we go.
About who the caretakers are in the home. Again, she mentioned that Terrence does some it sounds like engages in some parent behaviors, and he was the one who brought her. But the other 2 women, it sounds like there was just confusion about why they're there, or when they're coming back, or what their roles are. That's what I would say it was more of.
Okay, so there was nothing specifically that I'm understanding that you saw based on the relationship that caused you some concern. Like, for example, oh, there are too many people coming in and out, or oh, I don't know. Other than the fact that she was confused as to how to label the caregivers, you didn't see anything wrong with the mother's lifestyle to the extent that it affects her.
She's trying to be so
I mean, I
PC.
cannot make that judgment. I can't say that this lifestyle is wrong or harmful for this child.
Okay.
What I would say is that for most children, there is some, we hope that they would develop attachments to their caregivers. And the attachment between Ivy and her mom, it is atypical for a young child to decide to call her mom mother or heir, and call another parent, a step parent, mommy. That in itself is a little bit distancing, and I'm not making, I can't attach any kind of significant meaning to that other than it is unusual for a child that age. And so I don't know, I would have to do much more of an assessment to determine, is she confused about who she's supposed to be attached to? And the only thing that I could say is she talked.
Okay, so we have some people in here that are coming in. I'll real quick give you a recap. Mom is the PolyRouple queen. She's Ariel King. Dad, Mr. Maynard, is up top. It's a custody battle over more parenting time, who she should live with. Dad is remarried, living with another daughter and a son from the previous marriage of the wife. And Miss King, mom, lives in a PolyRouple environment where there is many, not couple, not several, but many, quoted, many people living in the same house. It's a polyamorous relationship, and dad isn't for it. He's Muslim. We could tell, not against it. But where the toe is coming in is there is a battle over how to take care of these daughter's 11th toe and whether it is a toe or a fungus. I will be quiet and let it play.
Talked about these other adults coming in
not
and
miss the
sometimes
toe.
being there and sometimes not. That's the only thing that I could tell you.
Okay. All right, thank you.
Okay. Should I leave the room now?
You're free, yes, you're free to leave. You're free to
Okay.
leave.
Thank you.
Mhm. All right, call your next witness.
Thank you, Your Honor. Ms. Alexander is going to do this direct examination. We are now going to call our client, Mr. Adrian Maynard.
All right, Mr. Maynard, you've already been sworn. You may proceed.
All right, good afternoon, Mr. Mayor. Will you please state your full name and occupation for the record?
Adrian Matthew Maynard. I am a customer service representative with the Social Security Administration.
And how long have you been employed with the Social Security Administration?
It's October of 2020.
Can you answer again, Mr. Maynard? Your sound cut out very briefly at the beginning.
October of 2020 is when I started employment with the Social Security Administration.
And how much do you earn there?
I'm not certain on my gross. I want to say it's around 47, but take home is about $1,000 every 2 weeks.
And do you receive any other income outside of your employment at the Social Security Administration?
I was recently approved for VA disability at a 70% rate.
Okay, and how much does that yield on a monthly basis?
My application was filed in October. My decision was given back in February. Starting this year, based on the cost of living adjustments at a 70% rate, claiming my spouse and the 2 children that live in the home with me, it's about $1,977 a month.
And what is your work schedule at the Social Security Administration?
It's Monday through Friday. However, the Social Security Administration as a federal agency has an accommodation made for religion. So I am permitted to work an additional hour or 2 on the clock every day, Monday through Thursday, and accrue what's known as religious comp time, which allows me to have a half day on Friday. So I get off at 12, I come home, I gather anybody in the house who's interested or willing to come with me to the mosque, and then I'm off for the rest of the day.
Okay. And do you work in office or remotely? It sounds like, well, can you just let me know, do you work in office or remotely at the Social Security Administration?
I'm sorry, let me back up real quick. You said that you gather anybody who's interested. Is the household Muslim or mixed?
My wife recently accepted Islam within the last 6 months. But as far as the children, we leave it pretty open for the children to read religious texts that they find interesting. So we discuss the Bible at times, we read the Quran with each other and go over basic principles of that, but they're not at an age where I want to impose any particular faith. I want them to find their path as I did mine. I just became Muslim a year ago.
All right, thank you.
In response to your question, I do have the availability for telework. Currently, the federal contract allows for us to have 2 days a week. However, my wife works from home, and we also have Esme, our youngest child, who's 2. So it's a little bit more difficult for me to have the proper environment necessary for me to get the type of work I need to do as a customer service representative, being on phones and things like that. So I opt out of my telework option in preference of working at work.
Could you ever opt back into the telework option?
My contract is set. It's Wednesdays and Thursdays on the first week of a pay cycle, Thursdays and Fridays on the second week. I actually recently exercised it due to like a throat cold or something. I just didn't feel comfortable being in the office and exposing other individuals to whatever I may have had going on. So Yeah, I can exercise that right whenever. It's not a need of having to put in a new request or anything. I'm entitled to that. I just choose not to exercise it regularly.
Where do you live, Mr. Maynard?
My exact address is 2525 Norris Road, Unit 38, Columbus, Georgia, 31907. Just a couple miles north of Fort Benning, about an hour away from Noonan, and about hour and 45 from the city of Atlanta.
And do you live in a house, an apartment?
I live in a townhouse. It's actually a condominium. I have a mortgage.
And who lives in your house with you?
Me, my wife, my stepson Jaden, and our smallest daughter outside of the visits that we get with Ivy.
Okay. In total, how many children do you have?
I have 3 children,
And
2 biological.
okay. And are you currently married?
I am.
When did you get married?
I was married January 23rd of 2021.
And what is your relationship to the defendant, Ariel Ham?
My
I'm sorry,
ex-wife.
Ariel King.
She's my ex-wife.
And when were you and Miss King divorced?
Our divorce was finalized around August or September of 2019.
Do you and Miss King have any children together?
Ivy Maynard.
Is Ivy your only child with Miss King? Can you answer again? Your sound cut out.
That's correct. Ivy is the only child that I have with Miss King.
And what is your current visitation arrangement with Miss King as it pertains to your daughter, Ivy?
Current visitation arrangement is alternating weekends, 2 weeks upon request in the summer, alternation of general school holiday breaks, and I get Father's Day every year. And then any 3 or 4 day weekends for holidays as well, we alternate.
And what about your daughter's birthday? Are you entitled to any visitation on her birthday?
Yes, I did request that it be outlined in the visitation order that I be permitted to pick Ivy up on the Friday closest to my visitation weekend in the week, upon the week of her birthday at 2:30 from school or a designated location.
And how long has the parenting plan that you're referencing been in place?
Since the divorce in 2019, there was a temporary visitation order that was put into place prior to that, but it wasn't the same outline. It was only every other weekend until a determination was made on our divorce.
And how far away do you and Miss King live from one another?
In the past, when I've had to travel to Stone Mountain to pick up Ivy for any reason, it's about 2 hours, give or take. Atlanta traffic and the time of day, it can take up to 2.5.
And generally, who is responsible for transporting Ivy to and from her visits with you?
Ariel King.
So Miss King would bring Ivy to visit you, or I guess, can you be a little bit more specific regarding how you all coordinate the transportation of Ivy from Stone Mountain to your house?
Understood. So she is brought by Ariel King from her home in Stone Mountain to a pilot gas station in Noonan, Georgia, which was determined to be the middle point. And then I travel from Columbus, Georgia to the gas station. We have a trade-off there, and then I bring her back on Fridays. I return her to that same gas station on Sundays to go back with Ariel on Sundays.
And regarding your visitation with Ivy, what issues have you had with exercising your visitation?
I've had visits that just weren't fulfilled. There were certain instances during the beginning of the parenting plan and visitation schedule where, because there was some ambiguity into the wording of the visitation schedule as to whether or not holiday breaks, 3-day weekends, 4-day weekends would require a switch of the typical every other weekend schedule, basically ensuring that either myself or Ariel doesn't go a full 3 weeks without seeing the child, because I get her one weekend, I get the holiday weekend the next weekend, and then I get the following weekend. I've reached out to get clarification on those issues prior to the weekend. I received no response. I'll show up to the gas station and she doesn't show. I'll show up the following weekend and she didn't show. But then adversely, there has also been instances where that same alteration has worked against me somehow. The biggest incident of my visitation being affected was the COVID incident. Ivy came to my house sometime in September. She had like a call she just kind of wasn't being herself as far as like seeming to be unwell. I reached out to Ariel just to get clarification. She told me that she didn't have any concerns, that there wasn't any evidence of Ivy being unwell at the time that she had her throughout the week. That Monday, my son Jaden tested positive for COVID. I notified Ariel that same Monday, and the dialogue that followed basically resulted in me being told that on top of presenting a negative test for Jaden, I would need to provide a negative test for everyone in the house, inclusive of the baby, 5-year-old at the time. I did some research. I saw where there were attorneys online saying that despite the COVID pandemic, that there shouldn't be any effects on your visitation or anything like that. And then at that time, the CDC had already they had dropped down their quarantine requirement from the 14-day requirement to a 5-day requirement. I informed Ariel that, or after Ariel telling me that she wanted Ivy to exercise the quarantining period and requesting the negative test results, I told her, fair enough, we'll do the 14-day, which was the previously issued order from the CDC, longer period. We'll do the 14-day and I'll get her my following weekend. That following weekend arrived. I reached out to find out if she was going to be present. When I got there, she was not present. Sent a text asking if she was going to be late. I received no response. I waited an additional 30 minutes, sent another text asking, or not at that point, I wasn't asking. I said, at this point, with you being 30 minutes late with no response, I'm assuming that you're not coming. I went back home. She reached out to me the following day on Saturday and basically said that I had never given her the requested negative test results. And I informed her that that's not something that I'm required to do, that we had already agreed that we were going to do the 14 days, which was greater than the 5-day requirement. And then I didn't get her the weekend after that. Altogether, it amounted to about 25 days. I went about 25 days straight without seeing Ivy. And that was basically my turning point, because despite the other concerns that I had with Ivy's well-being with her mother, the one thing that I did have that was consistent was my visitation. So once the visitation was encroached upon, that was when I seeked legal action as far as contempt and modification.
So regarding the COVID incident, you stated that you and Ms. Ham agreed to a 14-day quarantine for Ivy. Is that right?
If I recall, I have difficulty really establishing whether or not there was an agreement, only because whenever there's dialogue, all of our dialogue is done through text message. We don't really do any face-to-face contact. Whenever I present something, Ms. King has the habit of responding to particular portions of the dialogue rather than what is being presented in total. So it's possible that there was not a clear-cut agreement, but I had outwardly expressed that I was going to do the 14-day quarantine, and I don't recall there being any disagreements to that outside of, in addition, provide negative test results for everyone in the home.
And to your understanding, was the 14-day quarantine something that you were required to do?
No, from what I understood, that due to the COVID, though COVID was a thing, from what I had seen without seeking legal counsel directly, so much as just kind of Googling and seeing what the general response, that COVID was not to be used as a reason for withholding visitation.
Has your visitation been withheld with Ivy on any other occasions?
There was recently a situation with a fall break Ivy had been moved to a new school. I didn't have access to that school's calendar. And the day of my weekend visit, with no notice prior, I was told that I would not be getting my visitation that weekend because Ariel was exercising her visitation for that weekend per the parenting plan for a fall break. But there had never been any instances prior where fall break was applicable, and Ivy had been part of homeschool programs. So I was told, it was always presented to me that they were homeschool programs, or that they were what are they called? They were always associated as homeschool, not just daycares, but none of those facilities, whether they're called daycares or homeschooling areas, were ever presented to me as having a fall break. So it was never something that was addressed, nor was I informed prior.
Regarding not having access to the school calendar during the fall break, why didn't you have access to that school calendar?
I've had difficulty getting access to any of the school information. I know that Ariel had submitted when she first started at Choice Preparatory. She notified me.
Since I'm gonna be streaming this whole thing live, I know everybody's on the edge of their seat to see the toe. So let's go, because there's okay, so we have, I'm gonna go to the juicy stuff. This is the beauty of the live. Let's go to the juicy stuff, and then I'm gonna replay the whole thing. So let's see what mom put texted in this text.
Okay, can you all see my screen?
Yes.
Okay. Mr. Maynard, do you recognize the document shown on the screen?
I do.
What is it?
There are text messages between me and Ariel pertaining to that call dropping after the phone call I just described, and then reaching out later on to see about speaking with her.
The text message between who and Ariel? Your sound cut out.
Myself and Ariel, I'm sorry.
Okay. And does the text messages shown on the screen represent a true and accurate depiction of the text messages between you and Ariel on that day?
I believe so.
Your Honor, at this time, I move to have Plaintiff's Exhibit A admitted into evidence.
No objection to A.
Mr. Maynard, will you please tell me who sent the first?
I'm sorry, I was on mute. I was saying any objections, no objections, you may proceed.
I'm sorry, thank you, Your Honor. Mr. Maynard, will you please read the first three messages shown in blue, one at a time?
On May 12th of 2020, I sent a text saying, like to talk to Evie tonight. It'll be another 3 weeks straight of me not getting her, so a phone call would be nice. On May 16th of 2020, I sent a text saying, what happened? Did the call drop? On May 19th of 2020, I said, just tried to call Evie. Call me back when you get a chance, or just text me a good time.
Will you please read the next message in gray?
The response given was, there will be no good time for you to call my phone for her or anything else. You are welcome to provide a device to speak to her on tablet, iPad. I really don't care that you are able to call on per the parenting plan. While you have a right to speak to her, nowhere is my phone specified. Realistically, that was voided after the last incident. The one time I did allow, you had questions about the phone dying. I have nothing to say to you. And going forward, we have nothing to discuss. No questions.
Thank you, Mr. Maynard.
Wow, mom's petty.
Let me ask you, so what was the other way to contact her? Was there another home phone? What was the other way that she was referencing?
Tommy, her mom is petty.
At that particular time, there was not a specified alternative. It was that I
Not
could
specified. Was there another alternative? Could you call the home?
I didn't have a home phone. Ariel's phone is the only phone I could contact.
Okay, you may proceed.
That was actually my next question. So, Mr. Maynard, you did not have another way to contact Ivy besides Miss King's phone at that time. Is that correct?
Correct.
And so, after receiving this text message, how did you proceed with contacting Ivy after that?
I continued to make contact via Ariel's phone with no response. Eventually, Ariel responded to one of my messages and notified me that Ivy had made numerous attempts to contact me via Facebook. I don't really use Facebook, and I actually ended up getting rid of it later. But so I did go into my Facebook Messenger and I saw where I had a request from Ivy, because I didn't have Ivy as a friend on Facebook. There was a request sent to me from a page that was Evie Mama or Ivy Maynard or something like that, where she would say, "Hi, calling to talk to you." At this time, she couldn't. It was Ariel typing a message out to me, basically, I guess, attempting to facilitate.
How
and
old
then-
was Ivy at the time?
That was 2020. Then Ivy was 3.
So you were receiving messages from a page. Whose page were you receiving messages from?
The page's name was Evie Maynard, if I remember correctly.
Okay, and what did those messages say? You started telling me what they said. Can you finish telling me what those messages would say?
I don't remember specifically, but they were it was generally something along the lines of, "Hey, Dad, calling to talk," or "Hey, calling to speak with you," or something like that.
And how did you find out that Ivy was trying to reach you on Facebook?
After so many phone calls made to Ariel's phone with no real response, Ariel informed me that she reiterated, "I told you that you need to find your own form of communication. Since you have failed to do so, you can contact Ivy through her Facebook. She's made numerous attempts to speak with you through that platform."
Did you ultimately continue contacting or respond to Ivy via Facebook, or what did you do next for contact?
I spoke with Ivy via the Facebook app. It was like through the Facebook Messenger app for maybe a couple of months. What ended up being an issue is while Ivy talks on, at that time, Facebook, or now on FaceTime, she likes to utilize some of the emoji face modifying applications and things. She likes to play around with the device that she's utilizing to have the communication. And there was an incident where prior to that, we were having signal issues. We're no longer using cellular data between myself and Ariel's phones. We're now relying upon Wi-Fi or hotspot or whatever was being provided for communication. So there were a couple of texts where I would say, "Hey, the call's dropping consistently. I'm not able to hear her. It's breaking up," things like that. But eventually, the turning point was Ivy made a call to me, but then she also opened up a room, a Facebook room, to where people can watch, like a live, almost like a YouTube live. So she opened up one of these rooms, and I'm trying to explain to the 3-4-year-old, like, "Hey, hang up and call back, or let me call you a different way, because we don't need to talk here." Ivy wasn't able to understand that what I was presenting to her and didn't disconnect the call. And so then I sent Ariel a text saying, "Hey, Ivy's on a live right now. Can you facilitate?" No response. Ivy proceeds to talk to me on the live. I think one or two people might have popped in between there and then left. But after that evening, I made a decision that I was going to kind of push back on you can contact her through Facebook and say, "Hey, I want to be able to do a phone call, because she's not able to properly handle this application, and it's exposing her unnecessarily on the internet."
When Ivy is with you, how does Miss King contact her?
On my phone.
On your phone?
Yeah, she FaceTimes my phone directly.
And do you allow Ivy to talk to her when she FaceTimes your phone directly? Have you ever restricted her to any other forms of contact that is not contacting your phone directly? Where does your daughter currently go to school, Mr. Maynard?
Shadow Rock Elementary.
And how long has she been enrolled there?
Early February.
Who enrolled her in Shadow Rock?
Miss King.
And how did you find out that she would be attending that school?
She notified me around the same time, maybe a little bit before, a little bit after, but basically outlining the same concern that she had from Choice Prep, that she went from Lifeline to Choice Prep due to a lack of rigorous curriculum, and then said that Ivy had expressed that she wants to start riding the bus, being around same age kids, and also that she wanted a more rigorous education. So she was putting her into public school. And I told her that I thought that that was a great thing.
And prior to attending Shadow Rock, what school did Ivy attend?
She was in Choice Prep Academy, which was, I think its website listed it as an augmented homeschooling program. So basically, Choice Preparatory says that we are an extension to a homeschooling program. So because your child is not exposed to extracurriculars and things like that, because they're not in an actual school, like a public school, you facilitate the core curriculum, and then the child can come here to engage with same age children and have those the social development part be facilitated. So she was homeschooled, but was also kind of in attendance at Choice Prep. The rates of attendance vary because you can go one day a week or you can go every day of the week.
Okay. And when did you find out that Ivy was attending Choice Prep, the program?
A little while after the incident at Lifeline Christian World Academy, where I requested that the administrator, Rashonda, provide me with any records that she had of Ivy's attendance. Maybe a week or so after that, Ariel said that she was still trying to make communication with Rashonda, but that Rashonda had become resistant to providing that information after the incident, basically saying that because of my effort to get that information, that Rashonda basically had become hands off from wanting to engage her and providing that information. And so that, coupled with the curriculum not being rigorous enough, she was transferring her to Choice Prep.
Okay. And have you ever, I guess, engaged in a conversation with Ms. King regarding Ivy's curriculum with Choice Prep?
I think one of my main concerns, both with that school and when she was saying that Ivy was being homeschooled, is I didn't really understand how the core curriculum would be facilitated given her work schedule. Plus she's involved either as a partner or as an employee with Terrence King's photography business. So I asked her, how does she foresee facilitating the core curriculum, since that's not provided by Choice Prep? She works a full day and has a business venture on the side, and I never really got any clarification on that.
Did you have that concern regarding the previous school or daycare too, prior to Choice Prep?
Yes. Yeah, from whenever Ivy wasn't attending one of the previous daycares, homeschool, any of those facilities, Ivy would express to me that a lot of her time got spent at home with Terrence. Terrence, as an entrepreneur, he works his own schedule. Ariel has a structured job, so she would spend most of her days at home working on worksheets, is what she told me.
All right. Can you see my screen, Mr. Maynard?
I can.
You can?
Yes, I can.
Okay. Do you recognize the document shown on the screen?
This was one of the screenshots that we received from Rashonda during the deposition.
Your Honor, I'm going to object to hearsay to Plaintiff's Exhibit C. I understand counsel has not offered it or tendered it, but the fact that she's even projecting it and displaying it prior to setting the foundation, I would just go ahead and object to hearsay.
Okay, what's your response?
Your Honor, these documents were turned over in discovery via deposition, and also I have not, Mr. Maynard has not had the opportunity to authenticate it or anything yet. So I understand the hearsay objection, but like I said, it was turned over in discovery. Ms. Fari has had the opportunity to review this, and also she could have attended the deposition.
So in response, Judge, it's a communication from a third party that's not present here today for me to cross-examine. Secondly, it has not been authenticated. I have not received any business records verified by this third party in order for me to be able to interrogate her, cross-examine her, and further investigate. So that would rob me of my opportunity to confront the witness. It is certainly inadmissible hearsay.
Your response?
No further response, Your Honor. If the court is not inclined to it.
Objection is sustained.
Mr. Maynard, to your knowledge, has there ever been an issue with Ayevi's attendance at school?
Yes.
To what degree?
During the deposition, Ms. Rashonda, the administrator,
I'm
stated.
going to object to hearsay. This witness is testifying to statements of a third party that is not present today.
Mr. Maynard, please do not tell me what Rashonda said. Just tell me, to your knowledge, the issue regarding attendance. What do you understand the issue to be?
I'm going to object again to lack of personal knowledge. This witness intends to solicit information from a third party who is not present here today.
So I think hearsay is can be one of those things that yes, the information you gather sometimes from other people is hearsay. So you got to be careful about how you ask the question. You can ask how he understood it if it mattered to something else that you're about to discuss. Because everything we get is kind of generally hearsay, but it depends on how it's being used. If you're offering it as a foundation for something else, I'm going to allow it. But if you're using it for the truth of the matter asserted, that's another thing. So I'm not sure what do you anticipate him needing that information for? Did he respond to it in a certain way, or are you just giving it so that I'll understand that's what was said?
No, I'm not offering it for the truth of the matter because, as we mentioned, she's not here to actually authenticate whether or not it's true that Ivy was in school on that day or not. I am offering it to elicit testimony from Mr. Maynard regarding his understanding of his daughter's attendance at school, and further to elicit testimony from Mr. Maynard regarding his understanding of his daughter's educational placement. He has reasons for why he thinks that, but he cannot tell me that if he cannot tell me what his reasons are. Essentially,
oh, I'm sorry.
He does not need to tell me,
juicy with these two.
Read from the deposition transcript.
Right, what specifically she said, but I'm gonna condition it out. I think I know what you're trying to do, and I think so. I'll allow it to that extent. Go ahead.
Judge, if for the record, and just so I can follow along, maybe if the foundational question can be asked, how do you know? Like, where did he get this information from? I think that would help me too with discerning whether or not it's hearsay. If he said, I learned it from somebody who's not here, it's hearsay. If it's something personal that he knows directly, then okay, I understand that. But that was the reason for my objection.
Right. And what I'm trying to say is if you're listening information for the truth of the matter asserted, that's one thing. But if you're using it as to show how he responded or how he reacted.
The effect on the listener, it would be
like the effect on the listener, that's one thing. So I'm not really sure how you're using it. So if you're using it for that purpose, I'm going to allow it. But if you're using it just so that I'll know what someone said and I'm supposed to accept that as the truth, that's another thing. So
I'm offering it for the effect on the listener. And if I could give the court a little bit more leeway, if this is helpful.
Okay.
My next question would be, and what did you do? I'd like to know.
I'll allow it. Go ahead.
Mr. Maynard, can you please describe to me your understanding of attendance issues Ivy had with school?
As I understand it, Ivy was late on a basis that was consistent enough for it to be an issue with the provider, the daycare administrator.
And how often, to your knowledge, did Ivy miss school?
And I, at the time, was asking Ivy about any daycare from Lifeline, Christian World Academy, all the way into Choice Prep, how often she goes to school. So we're talking about from 3 to 5. She doesn't
Your
have
Honor, I'm gonna object to hearsay from the minor child. He started with, I asked,
Yeah, I agree. And then he's also going into the information regarding the school, how many days she was late. Now he can say she was late and it concerned him, but if he's starting to talk about the number and the actual days, that's the information that that is from the school provider, and we can't allow that. But if you want to, you know, if his position was she was late, I understood she was late a lot, and then consequently I did this, that's one thing, but he can't give me those specific pieces, because that's hearsay and that can't be challenged because the other person isn't here.
Thank you, Your Honor.
Okay.
Mr. Maynard, did you reach out to Ms. King once you became aware of the attendance issues Ivy was having?
Yes.
And what did that conversation with Ms. King entail?
all there really being a conversation. Most times that I articulate a concern in any realm, I don't really get responses generally.
So when you expressed your concern regarding Ivy's attendance to Ms. King, you did not get a response? Is that your testimony?
I recall.
And because of the attendance issues that you had to your knowledge, what did your perception become of Ivy's educational stance and where she was from an educational perspective?
I'm sorry, can you rephrase the question?
Yes, once you learned of Ivy's attendance issues, what did your perception of Ivy's current educational stance, and where she was on an educational level, what did your perception become once you were aware that your daughter was having issues attending school?
Concern was that she was going to fall behind.
And did that happen to your knowledge?
Not to my knowledge, but I also don't have access to a lot of the information to really make a determination.
We don't know what the nodding is going on, Scottish Lass. And I
Have you ever had concerns that your daughter was being neglected when in the care of her mother?
I love you guys, but this is my live, and we have to cut to this real quick, and we will go back to the toe. We're having fun here. I have to see what this is all about. Are you guys with me to cut to something real quick? It's something going on in Judge O'Brien's court. I just need to see what I am looking at. What is this? Are we ready? Okay, I am gonna catch shit for this, but I don't care. Here we go. What am I looking at? Somebody help me here.
The report. I wonder if we can at least accomplish
this has to be
having
good.
the defendant found competent today.
Is there any reason we couldn't do that, Mr. Vincent?
None. His attorney, maybe
Okay.
that could be questionable, but he's competent.
Okay, I guess I'm good. Keeper said OMG.
Okay. So, are you stipulating
The toe is
to
coming.
the results and the findings of Glenn Toplin, the psychologist and consulting forensics examiner at the Center for Forensic Psychiatry?
Yes.
And we got Michael Vincent.
Yes, Your Honor. The people stipulate as well as that you enter that as the only exhibit and find the defendant competent to stand trial.
And you're in agreement, Mr. Vincent, correct?
Yes.
Okay. I have reviewed that report, and it is the opinion of the examiner that Mr. Johnson is competent to stand trial. I am making that finding on both of these cases, that he is competent. And then I understand you need to get that criminal responsibility evaluation. Do you have any idea how long that's going to take them?
Your Honor, it's been my experience, sometimes it goes on for months. The last one I had went on, we got the competency report, I think in June. In December, we got a letter saying that the responsibility report is due. We finally got it in January. So I think Mr. Doby has done a little bit of research about how busy they are and how understaffed they are, which explains a lot what's going on.
Yeah, all that was a News or Free Press article, I don't remember which, from a week ago, saying that they have twice as many referrals as 10 years ago.
Okay, so should we set this out for about 4 to 6 weeks?
Yes, Your Honor.
He was bound over in January 22, and we've been waiting since April 2022 for these reports. So why don't we just set it over for about a month then? April 13th.
I'm here, right? Are
Or-
you Wednesday?
Oh, he's checking
So
his
if you would
hair.
like an extra week, the 20th.
What about the 20th, April 20th?
Ellie's
Okay.
checking that. I've been told that.
Okay.
I'm watching it. Oh, it's on the other screen.
Your Honor, they won't let me schedule anything.
He
So
starts to talk.
I have somebody here that does it.
Right. Mr. Doby, are you okay with the 20th?
Yes, Your Honor.
Okay.
And Mr. Doby, if I get something, I'll get it to you as soon as I get it, and hopefully vice versa.
Thank you.
And Mr. Vincent,
I
that
didn't say anything,
April
Kale.
20th
I
date,
said
is
nothing.
that good for you?
I've been told it's good for me.
Okay, at 1:30. So, Mr. Johnson, all bond conditions continue to apply, and you need to return by Zoom video for that adjourned pretrial. We'll see you then.
Thank you, Your Honor. Thank you.
You're welcome.
Okay, so I think we're gonna get to Mr. Moy now.
Center in Ann Arbor for an assault that they alleged you were committing. And they said that video showed that you grabbed the shoulder area of a Dylan Murray, threw him to the ground and kicked him in the face with the heel of your shoe, and then kicked him in the back before walking out of the center on foot. Although the victim only recalled being punched, not kicked in the face, but he had an injury on the right side of his mouth lip and complained of pain in his back, but didn't want to take off his coats to look for an injury. So at this time, Mr. Overwater, how do you wish to proceed?
Your Honor, I believe there's a recommendation for probation. I would ask that that be put on the record, but I do anticipate we'll be setting this matter for a hearing, and I would ask to be heard on the issue of bond.
Okay, what is probation's recommendation?
The recommendation is to revoke probation, 60 days jail with credit. I think he's at 25 days, and to sign a promissory note for the remaining $475 that he owes and waive the $25 late fee. I also believe he still has the show cause that's pending. It looks like he missed court on January 4th, and then the warrant was submitted after that.
Point of order.
The collection show cause?
No, there was a probation violation show cause submitted, and it was originally scheduled for November 30th.
Okay, I see that here. This case is pending before Judge
Judge
Conlon.
Conlon.
Yeah. So,
Your
Howard?
Honor, Oh, I'm sorry.
Yes. Yes, Mr. Dobie.
So, Your Honor, I believe that this defendant came into custody when he was arrested early this morning. He has been charged with carrying a concealed weapon in connection with that arrest.
Wow.
So
Plain
as far
innocent.
as bond, I'm
ain't
going to
screwing
ask
around, this
for a remand.
Point of order.
Mr. Overwater as to bond.
Well, Your Honor, I guess looking at Mr. Moy, I would put that finger down, please.
Put that finger down.
As far as the recommendation is concerned, I'm reviewing his ex-jail history, and I'm showing that he should have credit for 69 days. So if probation is recommending a revocation based on the allegations in the current warrant, I would ask that Mr. Moyes be permitted to plead no contest to those allegations, that probation be revoked, and he'd be sentenced to 69 days with credit for 69 days served, and then he can resolve the new matter, however that's going to be resolved.
So,
thank you.
Is that what you want to do, Mr. Moy?
I would really appreciate that. I have the money. With the missing of the hearings, I only had an Obama
Mr. Moore, I don't want you to talk about the allegations. Just answer the judge's questions, okay? Anything you say could potentially be used against you.
Okay, yes, Your Honor. If at all possible, that
was a
curveball.
That's something that you
sorry,
could
can you
do.
describe
I would
the
appreciate
concern?
it, and I would continue to do a little bit better as far as holding up my end, you know.
Whoa.
But if that's something that's a possibility, it is something that I would want.
Okay, do you believe that you've had enough time to talk with Mr. Overwater about what to do here today?
Yes, we discussed what was happening in my previous cases and how I was brought in, and yes, I think what he's saying definitely accurately represents my interests and
Am I being trolled here?
what's going on with me right now.
Okay, so do you understand that if you admit this or enter a no contest plea to this allegation, that you would not have a contested evidentiary hearing, but I would follow probation's recommendation?
The recommendation for 69 days.
Right.
And then I
revoke your probation, and you would, I would ask probation to repeat the financial part.
I can have the financial part paid.
Hold on, Mr. Moy.
Yes.
Your Honor, he'll owe $475. There's $25 in late fees.
Stay here.
That the court can waive.
Okay.
And could I ask the
Okay.
agent to confirm that jail credit, because ex-jail is just like frozen up on me. I'm wondering just if you could confirm that 69 is correct.
So I can say that was the recommendation for his court date he was supposed to have on January 4th. At that time, it said 24 days, but it looks like he did have an original jail credit of 52 days at sentencing. So I'm not exactly sure where the 24 was coming from.
Voice.
Okay.
Done.
And I don't have access to X-Jail, so I can call if we can pass it.
No, that's okay. If he had 54 days credit back, that's.
And Mr. Dobie, I can tell you,
that makes sense to me then.
In ex-jail, I'm showing that he served 58 days from October 10th, 2021 to December 7th, 2021. And when I pull up that booking, case 20-410FH is one of the cases on which he was held. And then he had another booking July 23rd of 2022 to August 1st of 2022. We served 10 days there. Again, case 20-410 is listed as one of the cases holding him. So that's 68 and then plus 1 day for today.
Thank you very much. Sorry about that.
Not a problem.
That's fine. So again, Mr. Moy, now hearing that, is that what you want to do?
Yes, Your Honor.
Okay.
Yes is good.
Yes.
Just a moment. So counsel, are you stipulating that the allegations in that warrant suffice to establish a factual basis for his admission?
Yes, Your Honor.
Yes, Your Honor.
Okay, so then are you pleading no contest to the allegation that you assaulted someone on December 3rd, 2022 at the Delana Center?
Yes, Your Honor.
Okay, satisfied, counsel?
Yes, Your Honor.
Yes, Your Honor.
And as to sentencing, Mr. Overwater?
And I'd waive a new report. I'd ask the court to proceed to immediate sentencing, sentence my client pursuant to the recommendation of probation, revoke his term of probation, 69 days with credit for 69 days served, and to waive the $25 late fee.
Mr. Dobie?
I have nothing to add. Thank you.
Why is he crying?
So is there anything you'd like to tell me, Mr. Moy, before I impose sentence?
I want to apologize for just how not reliable I've been with this process. I've been trying my best, and I just appreciate you guys. And I apologize that I wasn't able to complete probation because I really wanted to. I've been incarcerated, on the run, or under supervision since I was 14 years old. And I wanted to finish this, but if this is the way it's ending, I still appreciate you guys for letting it end.
What a lot of people, thank you, sir. What a lot of people don't realize is that probation is really there to try and help people stay on the right path, and they can help with, providing services.
It did this time. I wasn't mature enough for it the other times, but it did. It was a support system.
Okay. Well, I hope that there won't be a next time and that you've learned something from this. So I am following probation's recommendation. I'm revoking your probation, sentencing you to 69 days in the Washtenaw County Jail with credit for the 69 days that you've served. I am also waiving the $25 late fee. You're entitled to file an application for leave to appeal from your conviction and sentence. If you can't afford an attorney, one can be appointed for you. However, the request for appointment of appellate counsel must be filed within 42 days of today's sentencing. So how will you transmit that form to Mr. Moy, Mr. Overwater?
We will send that to him at the jail, Your Honor.
Okay. Good luck to you, Mr. Moy. Take care.
Thank you.
So that was a good story. Oh, that was a feel-good story. Mr. Moy threw us for a curveball. Whoa, I just needed to see that because that could have went a million different directions. And the Barry White, Forrest Whitaker look-alike in the comments, I almost fell off my chair. I don't know who wrote that, but that was great. All right, let's go. Let's go to the toe. And can we please make a comment about how this Elise and this nodding, it is so annoying. Does she have a condition? It's so annoying.
The first time the sock issue came up, or were you concerned about her wearing socks years before?
No, the sock issue didn't take place until after the shoe incident of me buying the new shoes.
Okay, and what year are we talking about then when the sock issue became?
2019.
2019 socks. Okay, all right, thank you.
It was after the divorce. So
After the
October, November after the divorce, the shoe incident took place.
Okay. All right,
Other concerns of neglect pertaining to.
Hold on, Mr. Maynard. Let me stop you. I'm gonna show you something on my screen. Can you see my screen, Mr. Maynard? Do you recognize the?
Okay, we have toe. The toe is in the building. Can we get a vote here? Comments. I should put a poll up. Is that a toe or a fungus? Toe or fungus? That looks like a toe. That does not look like a fungus to me. Toe or fungus? What are we doing here? I think it's toe. I see 1, 2, 3, 4, 5 toes, and then there's another one going on. They're gonna show it. I see 5, but what is that? There's an extra toe coming. Hold on. The toe is coming. Hold on. Don't jump all over me. The toe is coming.
The photo there, a few on the scroll. I need you to tell me if you recognize the photos that I'm showing you.
Yes, I recognize them both. That one as well.
I see toes.
What are
I
these-
see
what
no
are these
fungus.
photos?
These photos, that first photo is one of the first pictures that I ever took of Ivey's toe when I began to be concerned. This was right after this was either a little bit before or a little bit after the divorce, or once I got the temporary visitation, but she was very young, maybe two years old, something like that. That's pictures of her toes. And then those pictures after that was where I had these maybe 4, 5 at this time. I took her to go get her feet sized, just as clarification on the issue of the shoe size, whether it was 1 or 2 sizes too small.
And do these pictures that I'm showing you represent a true and accurate representation of Ivey's feet at the time?
So where is the extra toe? Can someone help me out here? Where is the extra toe, people? I see 5 toes. Do these people only have 4 toes in polyamorous families? Because right now I see 5 toes. Why is this extra toe or fungus an issue? I don't understand. That just looks like a 5th toe. Am I correct? I mean, the toenails are a little dirty, but there's no extra toe. Is it a fungus? It's a toe, correct? Okay. I had to clarify that because it was getting me crazy. I counted 5 toes. Why is this an issue? The bigger issue is, why is this kid in a household with 75 people swinging? Not the extra toe and wear the socks. Are we missing the bigger picture here? I can't. I had a vent. I'm sorry. Like, this is what it is. The 5th fake toe, or the lack thereof, a 6th toe.
You just described.
We have been robbed. Don't they know what's going on here? That we need to know what's going on?
Any objections to E?
I have no objections.
Are there
to
really
Exhibit
75
E.
people?
Mr. Maynard, in the first photo that I showed you, why did you take that photo of Ivey's feet?
I'm not sure if you're able to zoom, but if you look at the pinky toe, the cupping has started. You can see that her pinky toe had become brittle.
Listen,
almost. If you touch it, it crumbles. So the pinky toe issue had started.
I don't understand what you mean. It crumbles. What do you mean?
So
you mean
because
the skin underneath their foot?
No, the actual nail, the nail itself, because there was a fungus basically.
Oh,
there
I see.
was some.
Okay, the nail on her baby, on her on the nail.
Correct. The nail itself becomes brittle.
The toe falls off,
okay,
or the
I
nail?
See what you're saying. Okay.
In addition to that, I began to notice that there was a lot of like dirt and things like that collected underneath the toenails. And if you look at the right foot, that's kind of off to the side, that toenail was clipped. It appears that it was clipped, but if not clipped, then it actually broke away with a jagged edge, which is why you can see that there's on the right side of the big toe of the right foot, there's like a break off, and there's also dirt being collected underneath that toe. So it just was
Thank you, David.
It was a sign to me that there may be some concerns as far as like either she's not wearing shoes, or she's not getting proper foot care, or she's not getting her feet washed. But it was just one of the first things that I observed. And I was like, well, let me take note of this, if it persists.
Thanks, Lisa.
And in the next two photos where, what was going on in these pictures?
This was after she had been getting sent over in two small shoes for months at this point. I think by this point I may have came across 5 to 8 pairs of shoes on my alternating weekends that she gets sent over to me.
Okay.
With shoes that seem to be too small. We touch her feet. There's no give on the sole of the shoe because her toes are stuffed in. And so we said, well, let's go get her sized because when I bought that first pair of shoes during the incident in October, the response that I got was those shoes were placed upon her feet and a picture was taken saying, these shoes are an entire size too big. And so my response was, well, the shoes that she came in were a 6. The shoes that I purchased were an 8. If they're a size too big, then she should be wearing a 7. But either way, they're brand new shoes for you to have. And so in maybe two years old, something like that.
We have to, as a collective group, did they or did they not tell us there was an extra toe and this is an issue? Why do I count 5? Anyone? There's no, I mean, are they just talking about like the little toenail falls off on the fungus? Why is this? I don't get it. I just don't get it. These people are out of their mind.
But when you got Ivy's feet sized on this particular incident shown in the exhibit,
dramatic.
What size was she wearing, according to the sizing?
I believe she was supposed to be wearing an 11. Can you go up just one so I can get a clearer?
Yes.
Yeah, so she was supposed to be in an 11.
And what size was the shoe that she was wearing when she was sent to you for that visit?
Recall what size that shoe was specifically. She comes in various shoes. It's not like a single pair or 2 or 3 pair. The shoes change, but the sizes are always a little off.
I mean, I have a web toe.
Okay. And I'm going to show you
I do, actually. I have a web toe. Fun fact about time.
Can you see my screen, Mr. Maynard?
Yes.
Do you recognize the picture shown on my screen at this time?
That is disgusting.
That is a photo that I took on a Friday evening after bringing Ivy back to my home.
That poor girl wears.
She didn't have socks on, and there's dirt collected onto the insole of the shoe.
Ew.
Because she doesn't wear socks. And I guess when she's playing hard and everything else, there's dirt getting collected in there throughout the day, and she's stomping on it all day.
And does this picture represent a true and accurate representation of Ivy's shoes on the day that you took this photo?
Yes.
Your Honor, at this time, I move to have Plaintiff's Exhibit F admitted into evidence.
Plaintiff's F.
I just have a question about the time frame. I didn't catch the date.
Mr. Maynard, what was the date that you took this photo of the shoes?
I don't know specifically. Again, anytime the shoes are too small.
Oh, I'm sorry. I apologize. I told okay, I apologize. If I don't make this announcement, we might get cut off because this Zoom is also used for drug court, and it starts at 12:15. And so, Ms. Marshall, I know I told you to switch over at 12:10. Are we still in good shape? I'm just going to end now. We're good.
Yes, ma'am. I definitely would not have cut you off or switched you over without you making the announcement.
I thought it was programmed to cut off.
No, ma'am. It's a whole separate process. I just need you to announce the pause on this one so I can close it and move you over.
Okay. All right, then. Give me, I didn't even look at the text. Let me call and see what that other matter looks like so I can see whether we're coming back. But I think we're likely coming back. Give me 1 minute. I promise, Ms. Marshall. So hold on for a second.
Okay, so what's going to happen is they are coming back tomorrow at 9. So I'll have that on record, and we will get, I'm assuming Mom is going to talk tomorrow. So we're going to hear from Mom tomorrow without a doubt. definitely mom. She just says that it's a time. Stay here because I am going to play yesterday's Cowlitz, which I was going to do on the live, but we didn't have time. Cowlitz had some crazy custody stuff. Judge Fluffy, Judge Grandpa, whatever you want to call him, was on fire yesterday, and we're gonna play some Cowlitz right now. So hang out with me. It's only 3 o'clock. We got time, so let's have some fun.
Dollars a month. Have you made any payment at this point?
I have not.
And why not?
Since our last court date, is that what you're talking about?
Well, you haven't made a payment in a long time.
Ever.
You indicated you could pay $250 a month, and it would seem to me you would show good faith by making some payment by today, but it sounds like you haven't.
I can make a payment by the end of the month, that's for sure. A $250 payment.
All right, I'm not sure that's going to be enough, but
Hector,
Ms. Chapman, any
Yes.
response?
Yes, since I did not have time to respond to the declaration, I did actually prepare something to say. So today Bryce was supposed to submit a proposed payment plan written by him and his lawyer regarding the total amount owed. He has not submitted the payment plan. He has submitted a declaration. He has been found in contempt 6 times, does not show up to court, nor even attempt to follow an order. Nor did he submit his income to the court for our prior hearing. And at this point, I think the punishment needs to be served. He's delayed the proceedings due to making a claim he was going to be retaining a lawyer when he in fact was not, and also agreed to the court to be submitting that lawyer written payment plan to the court before today, and did not do either of those things. As far as the improper declaration, it does not state facts. It is not a viable payment plan. Instead, it was a way to buy time, badmouth me, and manipulate the system to avoid further punishments. Stating child support garnishes 50% of his paychecks is not accurate because it is also not legal for child support to do so. He also owes the IRS money, so they are taking for that too, as far as I understand. Referring to the clerk's notes, he was supposed to serve jail time, also was supposed to come today with the lawyer presented payment plan. His behavior time and time again shows he believes the rules don't apply to him. I'm ready for this to be done, being dragged out. An amount he says he owes of $6,500 changes many times throughout the declaration, but the total amount owed is $13,650 from my understanding. I would also like to request to see the receipts from the spousal support payments of $1,000 he claims to have paid to me, because I have never received $1. So maybe those were paid to Brittany Chapman, not Brittany Hancock, which is now my name.
All right, thank you. Mr. Chapman, any response?
Yes, Your Honor. I do have receipts, and I have receipts that she has signed. And yes, it was with Brittany Chapman on it because that was her name.
Those were maybe child support from 2 years ago.
Ms. Chapman, let's let Mr. Chapman respond.
And I have receipts from money orders that I've paid, that totals in that amount. So I would like to show, and I can show pay stubs of garnishment from child support of 50% of my wages since I started my new job. And I can present those and print those off and turn those in to show. And as far as a lawyer, I had legal aid advice. It was not a lawyer. And this is what we brought up and came to present.
Can I speak, Your Honor?
Go ahead, Ms. Chapman.
I believe that the receipts he is speaking about are right after he moved out of our house because I totaled up the receipts that I had because I believed that's what he was talking about. And that was when we were just going to be doing child support on our own without the court system. That was child support payments. And that was long before spousal support was even ordered. So I do have those receipts as well. But that is not towards this at all. And as far as child support, they literally can't garnish 50%. But if he says he can submit those, he should have submitted all the other things he was supposed to do.
Mr. Chapman, we've been here several times. Sometimes you were not here, although you were served. We've been here several times on contempt orders for spousal support and I think a payment for the car. And each time I entered an order to make those payments, nothing happened. I finally indicated that I was going to order 5 days in jail. And then the hearing after that, you did show up, which was the last time we were here. And I just want to check the date on that. That was on March 1. You were to come up with a payment plan.
Your Honor, did you want him to sign a
promise? You wanted more time to meet with an attorney. No attorney has appeared in this case. You've indicated that 50% of your wages are being garnished for child support. I don't believe that's true because wage garnishments are not that much of your wages, but we'll see. You've indicated you made some support payments. I don't have evidence of that. And honestly, I don't believe it's credible that you can't make a payment more than $250 a month.
Judge Fluffy on the case.
So I'm going to put this over, and if you've got something to write with, you need to write this down. I need to see wage stubs showing the garnished amount for at least the last 3 months. If you've made spousal support payments at any time, I want to see those receipts. And you need to pay Ms. Chapman $1,000 by the next time we get together, which will be a week from now. So that's going to be the 22nd of March. If I don't have your wage stub showing the garnishment, if I don't have the spousal support receipts, and if you haven't paid the $1,000, I'm going to order that you report to jail by the next Friday. If you don't report to jail, then I'm going to issue a bench warrant. So those are the things that are going to go on.
Jail. He's going.
This has been bounced along over and over without any meaningful response from you, Mr. Chapman, and it's time to have a meaningful response. So that's what I require. We're going to be back here on March 22nd. File all of those documents with the court so I have a chance to review them before the hearing. All right?
Okay.
All right. Thank you.
Thank you.
In an email, maybe let them know.
Okay, this one's even better than the last one.
Looks like I had ordered telephone or video visits twice a week. How have those been going, Mr. Blacklaw?
They've been doing pretty well as far as I know.
Okay.
Look at her.
Ms. Myers?
Well, I have a whole nother opinion on that.
You're coming through really light, so I'm going to ask you to speak up a little bit.
Can you hear me better?
Better, yes.
Perfect. Okay, so I have another opinion on that.
Okay.
Normally, these visitations are supposed to last normally an hour or so. They last maybe 6 minutes. Sometimes a range to 25, as long as they'll go. My daughter's span of paying attention, I guess, is like in a fragments of times when she gets super tired. So I'm not sure if they're purposely doing this to where she only wants to talk to me for a short amount of time and then rip the phone away, or what's going on, because I'm pretty sure we agreed it was supposed to be every Tuesday and every Friday, but I have only talked to my daughter over video chat 4 times. Well, sorry, 3. This last time, that was my bad. I wasn't home. But I did call her. So, I'm not really sure if he's making excuses for the times that he wants to go to his mother's to drop her off. But it's seeming like he's just not taking the initiative to do it on time. There were numerous amount of times where it was because the snow or this, which is understandable, but when I can drive through Woodland, in a little car perfectly fine. It's fine. I'm pretty sure he can drive in little bitty snow because I've seen him drive in worse. So that was an excuse. Secondly, when I do talk to my daughter, she is normally present, which is his mother, which is understandable because of the situation, but constantly trying to take the phone from my daughter because she can't hear me or see me or this and that, and constantly trying to fix the phone is a massive problem. So obviously this video chatting isn't working. So is there any other way we can do in-person visitations? Because if the phone call, the video chatting isn't working, what can we do?
Okay, thank you. Let me hear from Ms. Turnbull. Have you had a chance to speak to the parties?
I have. Mr. Blacklaw has returned his paperwork. I have had an interview with him. I've had a Zoom, visit in his home. I've seen Hazel. I've interviewed some of his collaterals. Ms. Myers has not returned her paperwork. She has had over a month to do so. She's been in communication that she's trying to. I've given her very direct information about how to do so. She has not done so. So that is where things stand with Ms. Myers. I have spoken with a number of collaterals and CPS, and I have some very serious concerns about how the child abuse that occurred to Hazel while she was in the care of Ms. Myers.
Hold on, buddy.
It was extreme and very concerning.
Mind you, Your Honor, these are accusations and there has not been anything filed. And as the person standing right there is going to find out, that those rumors are going to be squashed when they find out that the Sunday I picked her up, that she had red marks all over her body. So let's continue, Austin. We'll figure out who happened there.
Making sure to get in that Discord, Skippy.
I have proof on that one. I took pictures the day I got her. So we'll continue that in court.
All right, Ms. Myers, I'm not going to consider in-person visits until you provide the information necessary to the GAL and I get additional reports from the guardian ad litem. So it really is in your best interest to cooperate with her, because I'm not going to consider
times to send that paperwork through. I have contacted the UPS people that she has told me to go to, which I did that. And when I went over there, they told me that they could not find her IP address. So I don't know what else to do. I have tried asking her for a physical address that I can go to. I don't care what the distance is. I have asked.
Thank you, Laura.
I have tried doing a picture of the actual paperwork.
Do you have Ms. Turnbull's phone number?
I do have her
Make
phone
su-
number.
And you've been in touch with her, I think. Make sure you, well, you need to get her the what she calls a packet, which is.
Is she annoying the shit out of you? She's annoying the shit out of me. I don't know what it is. And Judge Fluffy's not having it.
Information that you need to fill out to get to her. Okay. All right. The order, the restraining order I'm looking at says that there will be 2 telephone visits a week. There's no indication as to how long they will last. We're dealing with a very young child at this point. I understand it's not optimal, but the court's interest is to make sure that the child is safe. And the best way to do that at this point is to keep the telephone visits. Mr. Blacklaw, try to facilitate those the best you can. But if the child gets distracted and doesn't want to talk after 10 minutes, I don't know that anybody can change that, because
She's
your
a year and a
child's-
half. We're
what
gonna
I've
do
got
it
is
for you.
18 months, I guess 18 months old now. So I understand that's difficult, but I can't order, I'm not going to order in-person visits until I get more information from Ms. Turnbull. Okay. Let's come back in a month and see where we're at then. So that will be April 12th.
Is there any way we can get it a later time? Because I'm
Then
going to
9
start
o'clock.
working here soon, and I'm not sure if
These are only heard at 9 o'clock, and I don't know when I'm going to call your case. So I can only set it at 9. There's one other docket on Thursday that's also at 9, but right now, for everybody's purposes, at least at the court, we need to keep it on Wednesday at 9.
Okay.
All right, so we'll see you back here on April 12th at 9 o'clock. And the telephone visits remain in place, okay?
Okay.
Thank you, Your Honor.
All right, thank you.
I didn't hear any of those.
It's going to take.
Birthday.
And coming into our, okay.
There you go.
Okay. So I prepared what I was going to say here. So I take full responsibility for the mistakes that I made. I was at that time unable to process the grief and the loss for my marriage ending and the trauma that I had suffered from the extreme verbal abuse. The abuse and harassment continued after we separated, as the police records show, to the point that I had a complete mental breakdown. And during that time, my drinking had become unmanageable, and I eventually ended up homeless. I do want to address some of the accusations presented in Curtis and Mandy's declarations, which are.
So this one, guys, is the another child support custody battle. Mom was alcoholic. Dad has custody. Mom's trying to get more time, and she's pleading her case in front of Judge Fluffy, and Dad's not having it.
Blanketed with false accusations. I never abused or neglected my son. He had good school attendance and never missed his doctor or dental appointments. There are no police records, nor had I been involved in any criminal activity or illegal drug use. I've made multiple attempts to contact Eric, but was denied every time, as even declared in their declarations. I've been completely alienated from maintaining a loving, stable, consistent, and nurturing relationship with my son, even knowing, as they declared, that Eric had separation issues and was affecting him mentally. On December 23rd of 2019, I filed and served documentation showing I was in compliance with the parenting plan provisions as instructed by Mandy Hart. And she said that they'd let me see Eric for Christmas Eve. Yet again, I was alienated and not even allowed phone calls, as I was told that was not enough. Your Honor, I respectfully ask the court to deny Curtis's proposed parenting plan. I'm currently on state assistance, as you can see from the fee waiver, and I don't have the means to do supervised visits in the facility. And I don't want to mess up any progress Eric has made over the last 2 years. That is why in my proposed temporary order that we begin with every other weekend. I believe that Curtis's proposed plan is nothing more than vindictive rather than him trying to cooperate with me and do what's best for our son. Curtis is not Eric's full-time physical caretaker. Eric has not been in Curtis's full-time physical care supervision since 2019, as stated on page 3 of Curtis's Life's Declaration. I've been in stable housing for over a year. I just renewed my 1-year lease last month. I have a 3-year-old daughter, and there's a declaration from her teacher who has been coming into our home once a week for her schooling since we moved in. I've also been in mental health counseling for over a year, twice a week, and I realized that I needed to address my mental health in order to maintain a lifetime of sobriety. Your Honor, I only have my son's best interest at heart. He needs me as mother in his life, and my goal is to have my son live with me rather than his grandparents full-time. I'm in treatment, and I have complied with the previous parenting plan provisions, and I've provided all the documentation showing so per court orders in April 2017. As you can see, no other court orders for modification have been signed by a judge other than the original parenting plan in 2017, and I've complied with Section 4 of that plan, and I respectfully ask that you grant my temporary order.
Mr. Hart,
Yes, Your Honor.
any response?
Yes. Well, Your Honor, my ex-wife, I was really hoping that she was going to take full responsibility for not being in her son's life for 6 of his 9 years, but it sounds like she's still trying to blame me for leaving the marriage that she had an affair and moved her boyfriend into the house. I moved out. She very quickly just kept on drinking to the point where I had to take her to court to get the papers are there. It's I'm sorry, I'm a bit flustered right at the moment. I had to take her to court to make her stop drinking in front of Eric, and she had him removed by the courts for several weeks. When she got him back, she destroyed every single thing inside of her house, all the glass. She did that in a blackout rage the day she got Eric back from not having him for several weeks because of the drinking issues. After that, there was a contempt of order charge that was levied by the courts because of that drinking incident, and that's why she can't see her son. She's never lost custody. I have to also follow the court order that allows her not to see him, and the ball has been in her court this entire time. She's never filed anything as far as I know. I've never been served anything by anybody. There's a lot of what she just said is just false, and what I'm
While to remove the 2018 suspension in order to see her son. I think we need to take a couple steps before we get to that point. And so, Ms. Hart, I'm going to tell you up front that I've been through this process a number of times where a child has not seen a parent for a while, and we have to reintroduce or introduce the child to the parent and do it in a way that's safe. And it's going to take so long, you're probably going to be very frustrated. But I want you to look at the end of the road where you will have a fairly normal relationship with your son. But we need to take some steps to get there. The first step I'm going to do is appoint a guardian ad litem to do an investigation of Ms. Hart and also just look at the whole living situation for Eric. So I need to do that first. I'm not going to order any kind of contact between Eric and Ms. Hart for at least a month while the guardian ad litem does an investigation. And that's because I'm not sure what that contact looks like. I don't know if telephone calls are appropriate. I don't know if reunification counseling is appropriate. I need assistance from the guardian ad litem in order to determine that. All right. The order that Ms. Hart provided was an order on adequate cause. And I wanted to address that. I'm not sure that at this point, that's the order we want. Let me just person. There we go.
I'm sorry, Your Honor, I can't hear.
Yeah, I just muted somebody.
Thank you.
We may do an order for adequate cause, which would cause you to go to a trial to change the parenting plan from what it was in 2017. But right now, what I see is I'm addressing whether the contempt order of 2018 should remain in effect. And if not, how does that change? I think that's something I do from this docket. And so I'm going to retain everybody for a while, at least until we get a guardian ad litem report, and maybe take some steps to reunite Ms. Hart with Eric. Okay. So the way we appoint a guardian ad litem is we give 3 names. If you know of any of these people, let me know, and we'll see whether they're appropriate to go forward or not. So the individuals are
Heather Paul, David Turnbull, and Ann Hyde.
I didn't hear any of those.
okay. So I'm going to tell you Heather Call. I think it's Kahl. Amy Turnbull and Ann Height. Either of you know any of those? Okay.
Oh, we know Ann Height.
So I'm going to appoint Heather Call
Ann
as
Height's
the
Judge
guardian
Fluffy's
ad
right-hand
litem
woman.
here.
They have matching fluffy doos.
All right.
I swear he reminds me of.
I'm going to put this over a month, and that's going to be to April 12th. To give Ms. Call at least some time to meet with you and get started. I don't know that she'll be completed in her investigation, but to get started. In the meantime, nothing's going to change. That contempt order will remain in effect. Ms. Hart, you're not to have contact with Eric
That jury, Michelle, I got
until we do this investigation. Okay.
Okay.
Mr. Hart, any questions?
So do I contact Ms. Call, or does Catherine?
She should contact you. In the order that I put together appointing her, I provide your contact information.
Okay.
So she will contact you. Good
All right.
question. Ms. Hart, any questions?
No.
Okay. All right. We'll see you back here on the 12th, and we'll go from there.
Okay, thank you, Your Honor.
All right, guys, there it is. I hope you enjoyed it. We munched around a little bit. Thank you for all of your supers and all of the donations you guys made the last couple weeks. The new computer will be delivered to my doorstep tomorrow by 10 a.m. That means I will be live streaming on the new hardware. No more. All the problems I can't blame on the computer anymore. So if I mess up during the live, it's my fault. I take full blame because of you guys. I have a brand new hard drive, screen, double screen, everything going on. It's for the channel. You guys are the best. I could stream all day, but I have my daughter to take care of. I will see you guys tomorrow. I will announce the time. Always look for the time that I'm posting, because sometimes I'm at work, sometimes I'm not. And I'll be able to stream during the day, sometimes after school, all the things. So everyone just keep your notifications on. Make sure you guys are liking all the material. keep it light in the comments. And when I hit 5K, I'm doing an all comment live stream. I'm going to compile the worst and best comments of time served since the beginning, and there are some doozies. Just imagine what people say about me in those comments. So I love you all, and you guys have been served.